Okay, well, good afternoon, good evening, everybody. And you are the hardy souls that have returned after last week. We've got three slides, I think, left to finish the Articles of Confederation, and then I'll explain why it was so important to go through that. So I guess we should, well, let's go to the protocol uh, since we have some new people. Okay, you can basically read that. Chat your questions using the chat thing at the bottom of your screen. Lena will be watching those as best she can and let me know if there's anything that I need to give some follow up on.
If for some reason,
that,
if for some reason we miss your chat question and it's urgent, go ahead and unmute yourself and interrupt.
Okay, so let's move on to our next slide, which is the Articles of Confederation. I think there are only three more slides left in this series. Just a real brief recap. In 1776, when the Continental Congress declared its independence from England, it had created a confederal form of government called the Continental, I guess they call themselves the Congress, under the Articles of Confederation. Its primary purpose, this document's primary purpose, was to create a mutual defense treaty, such as NATO is today, where the 13 states promised to come to the aid of any one of them if they were under attack. Main purpose was to help fight the Revolutionary War. Had a number of flaws, which we'll discuss in just a couple of minutes when we get to the end of this. So let's just dive into Article 10, which essentially says that Congress shall be run by the decision of any 9 of the 13 members. And remember, every state gets just one vote. So it doesn't matter if you're a small state like Rhode Island or a big state like Virginia, everybody had an equal voice. We'll talk about the problems of that when we get to the Constitution. Anyway, so that was the way they operated. And as soon as 9 states agreed on something, it would be enacted. Moving on to the next slide, which should be slide number 4. This one is just historical fun. If you can picture a map of North America in the 1770s, you know that on the East Coast there were 13 colonies of England, which would ultimately become the 13 states that broke away under the Declaration of Independence. But what was to the far north of those 13 colonies? There was a place called Canada, and that was a dominion of Great Britain. Well, the colonists just could not understand why Canada did not want to join in fighting against the British. So they stuck this in because they knew sooner or later that Canada would come to its senses. And so they put this in explaining how Canada becomes part of the United States as soon as they come to their senses. So that's just historical fun. Number 12 is basically that all monies borrowed, debts contracted under the authority of Congress, basically to run the Revolutionary War, shall be deemed and considered a charge against the United States. In other words, the United States was assuming those debts. We will talk more about that in the Constitution. And let's move on to, I think, the last slide here. Article 13, if you are superstitious, You would never create a document that has 13 articles, because as we said before, this document is just fraught with problems. But the thing I want to highlight here in Article 13, you will see the mention of the perpetual union mentioned 4 times in this article and 1 time at the very beginning of this document. The union shall be perpetual. What did they mean by this? The states, once they entered this union, it was like the marriage that there is no divorce from. You remain in it forever. This will not be repeated in the US Constitution. Now, just I think an interesting sidelight. Imagine if this document would have survived, if it had been written better and actually functioned. Could there have been a civil war? The Union was perpetual. No states would be allowed to secede. So kind of just keep that in mind, and you will see that this document was agreed to by Congress in November of 1777. But it doesn't become ratified until 1781. This 4-year period is kind of interesting. And why did it take until November of 1777, fully a year and a half after the Declaration of Independence, to even write a document that created a national government, although a weak national government? Shortly after the Revolutionary War began, as you know, the colonists were not doing very well. They were losing. They were losing a lot of battles. In 1777, it was right after 2 wins, Lexington and Concord. But as we got into the latter part of 1777, it didn't look like the Americans were going to win this Revolutionary War. So the states were wondering, why should we ratify and join this? If it fails, the king is going to be pissed off at us, and maybe we should hold off. And so it took until 1781 for 9 states to ratify it. Here are the interesting historical considerations. What happened in 1781? America had its biggest victory in the Revolutionary War, and that was the Battle of Yorktown, which was basically the last major battle of the Revolutionary War, which prompted the king to essentially sue for peace. He had come to the conclusion that the cost of fighting the war in America was too great. It put the homeland of Great Britain in too much danger from attack by the French and the Spanish, because so many of their troops were fighting in North America. So the king decided it's time to end this thing. Here is the problem that the creation of this Articles of Confederation created. Who is the king to negotiate with for peace? You can negotiate with the Congress, but the peace treaty couldn't go into effect until 9 states ratified. The most interesting argument, they said that had fort on the Canadian border right next to New York, and that New York would not agree to the peace treaty until those forts were closed and those troops were removed. Other states had their own objections. Problem was, in 1781, you couldn't get 9 states to ratify the peace agreement that the United States and England entered into. And you can understand why the English were so hesitant to deal with the Americans, because what government are you dealing with? A national government that has really no power, Or did you have to convince 9 individual governments to sign the peace treaty? And as soon as you bring in those 9 individuals, they're going to have all kinds of issues. But finally, in 1783, a peace agreement was entered into between the United States and Great Britain. This ended the Revolutionary War. Historically, when you have a big war and the war comes to an end, countries that were engaged in that war go through bad economic times, generally a recession, sometimes a depression. The reason being, during your big war, you had to take large numbers of civilians and turn them into soldiers. So they couldn't be working on the farms, they couldn't be working in the factories. What do you do to replace those people? You hire women, you hire children, you use slaves, you do whatever you can. War comes to an end. First thing a government wants to do is muster out all of the troops that they have on their payroll because the war is now over. You now have a flood of labor, and what happens is generally an economic downturn. So that started in about 1783, 1784, once the peace treaty was signed. It got really bad by 1786, especially in the state of Massachusetts. What had happened in Massachusetts was the state government, because they weren't paying their taxes in to the national government for payment of the Revolutionary War, the state government was issuing warrants to its soldiers, promising to pay them in the near future. Very similar to what happened after World War I, when the United States gave similar kinds of warrants and guarantees to the returning soldiers that they would receive a pension like 15 years later, which was wiped out during the Depression. Anyway, the state of Massachusetts was bankrupt because of its war debt, and it needed to raise money. For the first time in its history, Massachusetts passes a new tax law. It taxes farms for the very first time. And it was sort of draconian. If you didn't pay the tax, the state of Massachusetts would foreclose on the farm. So there was a fellow who was, he was an officer during the Revolutionary War fighting for the Massachusetts militia, and his name was Daniel Shays. And Daniel Shays, he had all these warrants, promises for back pay from his military service in the Revolutionary War. He kind of knew he'd never see that money, but he was fine with that. He felt he did his patriotic duty. But now the war is over, and he wants to go back to his farm and become a farmer again. But the problem was this economic depression in Massachusetts. He couldn't pay the taxes on his farm. His neighbors couldn't pay the taxes on their farms. Remember in those days how a militia was formed. The state would pick somebody, for example, Daniel Shays, and ask him to recruit people for his own militia to fight on behalf of Massachusetts. So who's he going to go to? Shay goes to all of his neighbors, and quite a few of them become members of his militia. They're all now facing the same economic problems that Daniel Shays is. And when Daniel Shays receives the notice that his farm is being foreclosed, he got, as you can imagine, rather pissed off. And I've always had a philosophy that you don't piss off guys that have trained with guns. When they tried to foreclose on his farms, Shay got all of his former militia members together, and they decided to march on the town of Springfield in Massachusetts. Now, why did they pick Springfield? As you recall from last week, every state was required to develop basically an armory to keep public stores of military goods to use to fight to protect their state. In Massachusetts, that armory was at Springfield. These rebellious folks, former militiamen, captured the armory. Would you say that the state of Massachusetts is now in rebellion? Short answer, I guess, is yes. This document, the Articles of Confederation, had the passage. If there's any kind of insurrection, attack, rebellion against any one state, the other states are to come to their aid. Massachusetts does exactly what the Articles of Confederation require. They send notice to all of the neighboring states, hey, we've got a rebellion, we can't control it, we need the help of the neighboring states. And the response of the neighboring states was pretty much the same. Sorry, Massachusetts, we have problems of our own, we can't come. And Congress is sitting here looking at what's going on in Massachusetts and saying, how the hell can we operate a nation when we can't even protect one of our states from a bunch of armed farmers? Clearly, the Articles of Confederation does not work because it had no enforcement. Couldn't enforce the militia, you couldn't enforce the aid, the military aid from one state to another. You couldn't even enforce the collection of taxes. It was a disaster. So the Shays Rebellion, which ran from the end of 1786 to about the middle of 1787, finally got Congress to realize the Articles of Confederation that they had created was a disaster. So the determination was made by Congress, we need to fix this. We're going to put together a select committee, and they are going to review the Articles of Confederation and try and figure out what its problems are and how to fix those. And they would meet separate from Congress so that they'd have some degree of privacy. They put a fellow in charge who was a Revolutionary War hero by the name of George Washington. He took this delegation to another building in Philadelphia. He ordered that all of the windows be closed, the blinds drawn. He ordered that all of the doors be locked. And he took a poll of the delegates. And he said, how many of you think that the Articles of Confederation can actually be fixed? And he got very little positive response. So he said, and I agree. So the reason I'm locking the doors and you are all being sworn to secrecy, we are going to not follow the instructions of Congress to fix the Articles of Confederation. Instead, we're going to create a new form of government that would be much more of a national government, much more central power to the national government. And they were all sworn to secrecy. They couldn't tell Congress about it because if Congress heard, what would they do? They would recall the committee saying that's not what your purpose was. So our Constitution, which means so much to us, born in secrecy and in violation of the rules set by Congress to try and fix this. So on we move now to the next slide, United States Constitution. This document was written in 1787, as we said. They managed to knock this thing out in about 4 months. It solves most of the problems that were created by the Articles of Confederation. And of course, it's going to create some new ones. So of course, here you have the famous preamble. A lot of grammatical experts point to this and say, wow, the first 3 words of the Constitution of the United States in the preamble have a grammatical error. We the people, it should be we, comma, the people of the United States. And under modern usage, that would be the correct grammar for this. Apparently, it was not necessary for that comma when they wrote this, or perhaps they made a mistake. But let's take a look at the language. And as we're about to go into this Constitution, I need you to remember a couple of things about it. This law will, or this Constitution, will become the supreme law of the land. It shall govern all 13 states. I think at the time that this was enacted, there were actually 15 states. But it fixed some of the main problems of the Articles of Confederation. It gave Congress control of the chain of command of the military. You remember that under the Articles, the individual state legislatures appointed all of the officers of colonel and below, and they didn't feel that they had to respond or report to the generals, which were appointed by the Congress. So you had a breakdown in the chain of command. You had problems in the training of the military because each state would train their militia, if they gave them any training at all, differently from their neighbors. So can you imagine trying to go in and fight a battle with militia from several states when they had different training, they've got different weapons, they've got different uniforms? It was chaos. So the preamble actually does a really good job of explaining the problems of the Articles of Confederation. So let's just look at the language here. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Very nice language, but let's break it down a little bit. First thing, in order to form a more perfect union, what did they mean by a more perfect union? They had a union under the Articles of Confederation. It was a disaster. This one's going to be better. Why is it going to be better? We are going to establish a justice system that wasn't created in the Articles of Confederation. The individual states there were allowed to create their own justice system. We're going to establish a uniform justice system at the national level. We're going to ensure domestic tranquility, so there will never be another Shays Rebellion. We will provide for the common defense. In other words, not every state out there on their own doing it their own way. We will have a common system. And then we go into la-la land here. We're going to promote the general welfare and secure the blessings of liberty to ourselves and our posterity. Okay, that's pretty vague, but you can tell from the beginning of this, they had particular things that they intended to fix. So on to our next slide. Article 1 of the Constitution, and before I get too much farther, I want you to pay particular attention. The first article of the Constitution creates the legislative branch, Congress. The second article of the Constitution creates the executive branch, the presidency, which is the president and all of the people under him. The third branch creates the judicial system of the United States. There are going to be offices mentioned in each of these documents or in each of these sections. When an officer is mentioned, for example, President of the United States, he's in Article 2 of the Constitution. He has Article 2 powers only. Congress, created in Article 1, they have the legislative powers, and it's vested in the Congress, which shall consist of a Senate and a House of Representatives. Obviously, there are going to be people, who are the senators, and people who are the House of Representatives. They are all considered Article 1 officers. The key here is, and this is the beginning of the concept of separation of powers. Article 1 officers can't be told to do anything by Article 2 officers, and vice versa. In other words, the officers of one branch of the government do not have authority over the other officers in the other branches. So this is the beginning of your separation of powers, which is so important here in the United States. So I've highlighted all legislative powers are vested in a Congress. If you have a copy of this, you might want to underline all, circle it, highlight it, asterisks, whatever. There is nothing unclear about this. If it's a legislative power, it belongs to Congress. The president does not have a legislative power, and the court system does not have a legislative power, because Section 1 says legislative power belongs to Congress and only to Congress. I think we hit that. Let's move on to the next slide. Section 2 of Article 1 talks about the creation of the House of Representatives. So some of the things that we're going to look at, and I'm going to compare them to what failed in the Articles of Confederation. Members of the House of Representatives shall be chosen every second year. This is different from the members of Congress that were under the Articles of Confederation. They served one-year terms. And remember that they had term limits. They could only be a member of Congress 3 years out of a 6-year period. After that, they couldn't get reelected. Why did they change this from 1 year to 2 years for the House of Representatives? It helped create continuity of government. An example would be this. Under the old system, you'd have a Congress, congressman would be elected, kind of popular, so he gets reelected next year, still popular, he gets reelected the third year. Even though he remains popular, he cannot serve a fourth year because he's served 3 years in a 6-year period. That happened to a number of really good congressmen in the Articles of Confederation, people who knew what they were doing, and the longer you're in office, the better you know how to do what you're doing. And as soon as they became really proficient in what they were doing, they couldn't hold the office anymore. So the change here was made. They'll be every second year. They'll have 2 years. And you'll see a little bit later, there is no term limit on how many years they can be or how many terms they can serve as a member of the House of Representatives. Parenthetically, let me add one thing here. This article creates a Congress that is composed of 2 houses. The first Congress under the Articles of Confederation, similar to the Continental Congress prior to the Revolutionary War, was a single house, what's known as a unicameral legislative house. They are creating 2 houses. We'll talk more about that after we get through the Senate version. So now, who can be a representative in this Congress? You have to be at least 25 years old. You have to be a citizen of the United States for 7 years. And you have to live in the state that you're representing. Note that you don't have to live in the congressional district that you're representing, but you do have to be an inhabitant of the state that you're representing. So first question my students often had is 25 years old. Is that too young? Why did they set it at 25 as a starting date? A lot of folks say, well, people didn't live so long back then. Yeah, well, I'll tell that to Benjamin Franklin and John Adams and Thomas Jefferson. People lived to be quite old. But the reason that they wanted people as young as 25 was that they realized we're creating a new nation here. It's going to require vigorous activity. Younger people can do it better than older people. So we don't want to preclude new ideas from the fresh blood. We want to give people starting at the age of 25 the opportunity to serve the government. Second thing, 7 years a citizen of the United States. You do not need to be a natural born citizen to be a member of Congress. You can be born anywhere. You do have to come to the United States and become a citizen through naturalization process. And once you've done that for 7 years, you're eligible. So at the age of 18, you can move to America, become a citizen, and at the age of 25, you're okay to be a member of Congress, a member of the House of Representatives. So those are the restrictions on who can be a member of the House of Representatives. Let's go to the next slide. Since there are going to be a number of representatives, the number has to be determined by something, and this is apportionment. This is the beginning of gerrymandering right here. Representatives will be apportioned by the population of their state. The more populated the state, the more representatives they would get. A question popped up here from Donald about what's the magic about 7 years. You're going to see several things in here that were just a matter of compromise. This happens to be one of them because you'll see it's a different term of citizenship for the United States Senate. A lot of this, from what I understand, is biblical. 7 is a magic number, 9 is a magic number in the Bible, and 13 is a magic number. So you'll see some of these numbers reflected. It was just a matter of that's what they agreed to. Nothing really magic about 7. Okay, so the states are going to get their representatives apportioned based on population. The more populous a state is, the more representatives it would get. This kind of defeats the purpose of the Articles of Confederation, where every state got a single vote. Now, a state like Rhode Island could not cancel out the vote of a state like Virginia. Virginia got more power in the House of Representatives because it had a bigger population. You'll see that who was to be counted. This is the infamous section about a whole person, the whole number of free persons are counted. Indians are not counted, and 3/5 of all other people, the slaves, would be counted. All free persons counted, I guess there's nothing to discuss there. Why were Indians not counted? Was it racism against the Indians? Partially, but it was something else. And that is that the government of the United States, going back to the Continental Congress, recognized that Indian communities were their own separate nations. And they were recognized as their own separate nations. And since they were a member of a separate nation, they shouldn't be counted into the population of our nation. So part of it was racism, but part of it was just the fact that Indians were not Americans. They were members of their own tribal government. So for Donald, the 3/5 of all other persons, what was the story here? This was one of the initial great compromises. Southern states, a large part of their population was slaves. If they were allowed to count the slaves, they would have equal or maybe even more power in the House of Representatives than the northern states that didn't have slaves. The northern states said, we'll let you count your slaves, as a complete whole person as long as you give them all of the rights of a whole person. The southern states said, well, no, we won't do that. And oh, by the way, you remember that Articles of Confederation and Perpetual Union, the only way to get out of the Articles of Confederation, which everybody agreed was a disaster, was that you had to get unanimous consent of the 13 to get rid of it so that they could adopt this. And the South played this card, the North did too, where they said, well, you know what? If you don't give us some consideration on this, we will vote no on getting rid of the Articles of Confederation, and you're stuck under that. So what happened here was the compromise. Why is it 3/5? Why is it not half? Why is it not 75%? It's just the number they finally compromised and agreed to. And you see that with the 14th Amendment, that all that goes away after the Civil War, and all people are counted. And when we get to the 14th Amendment, you will see all people are counted. Do you need to be a citizen of the United States to be counted? No. Do you need to be of a certain age? No. Do you have to be registered to vote? No. If you are a person, you are to be counted under the 14th Amendment. We'll obviously talk more about that. Now, if the representation to Congress is going to be based on population, who do you leave the counting to? Are you going to let the states do the counting? Are they going to cheat? Are they going to say, oh, look off there in the distance, there's a person, let's count them? Somebody else might say, I don't know, it looks like a cow to me, but go ahead and count them. So the determination was made that the states couldn't do the counting because they would be, working in their own best situation, and that the federal government is going to do the counting. So the federal government now establishes a census created here by the Constitution, even though the word isn't there. The enumeration, the counting, shall be made under a direction of the Congress of the United States, and the direction was we will create a Census Bureau. The count, because it would be obviously a big undertaking, will be done every 10 years. And now let's take a look at a blunder they were able to fix, but clearly they weren't thinking about the future of America. Representatives will be apportioned to each state based upon their 30,000 population. So if they have over 30,000, they get a second. If they have another 30,000, they get a third. So for every 30,000, they would get one representative. In 1787, that might have made some sense when the population was like under 10 million. Population of the United States now is approaching 350 million. If you do the math, how big would Congress, the House of Representatives, be today? Be slightly over 10,000 members. So clearly this one representative for every 30,000 isn't going to work. In actuality, today, it's one representative for something like 975,000. And by the time this new census number comes through, it's probably going to be one representative for slightly over like 1.1 million. So a small state, even if it didn't have 30,000, would still get one representative. And they just arbitrarily said that the very first Congress are going to have these numbers of representatives assigned until obviously the first census is conducted, and that would happen in 1790. Okay, let's move to the next slide. So what happens if you have a member of the House of Representatives who dies or resigns or gets sick or otherwise can't do the job in the middle of their 2-year term, the state executive power chooses the person to fill the vacancy. They can do it in a variety of ways. Every state has their own. They can call an election within their state to fill the vacancy. But a lot of states just say, it's only for 2 years, so let's let the governor, the person to fill up the vacancy. So when vacancies happen in the middle of a term, each state has its own rules on how to fill that vacancy. House of Representatives shall choose their speaker and other officers. So I'm going to point this out right here. Speaker of the House is an Article I officer. He or she has authority within Article I, within Congress, but not in Article II or Article III powers. But who becomes president if the president and vice president are no longer able to hold the office? Speaker of the House. Is the Speaker of the House now also an Article II officer? That creates a problem or an issue, which we'll talk about in a little bit. Then we have this concept of the House of Representatives shall have the sole power of impeachment. We've all experienced this, that the impeachment process, which you all probably now are very familiar with, is that the House of Representatives, when they make a determination that some member of an Article II or an Article III office is not doing their job, has done something bad enough that they shouldn't remain in office. So an Article I institution has the power of impeachment over an Article II officer or over an Article III officer. But there is no impeachment within the Congress, within the House of Representatives. There are other ways of dealing with problems within the two houses. So the House of Representatives has the sole power of impeachment. And I think we all know that when we get to talking about the Senate has the power to try all impeachments. So it's a two-pronged process. The House of Representatives has to determine some Article II or Article III officer has done something so bad they need to be removed from office. They basically write up what the complaints are. They send it to the Senate. The Senate tries that person for those issues, determines if those issues are bad enough that they need to be removed. And so that's the two-part process. Got a question here from Warren about how did they come to the 435 members of the House of Representatives. That was done, I believe it was in the 14th Amendment, where it became clear that one member of Congress for every 30,000 wasn't going to work as the population of the United States started to grow so rapidly. So they just put a cap and said it's going to be 435 seats in the House of Representatives. Every state is guaranteed at least one, and the other 385 are apportioned based on population. So I hope that answers Warren's question. Let's move on to the next slide. Talking about the Senate now, the other house of Congress. And I would always tell my students, when you're talking about Congress, be very clear. When you talk about Congress, you are talking about the combination of the two houses, the House of Representatives and the Senate. Too many people call the House of Representatives Congress. So they say the House of Representatives is Congress and the senators are the senators. That's technically wrong. The House of Representatives is the House, and the Senate is the Senate, and the two of them together create the Congress. Okay, so in the Senate, each state shall get two senators. Um, Under the Articles of Confederation, every state got one vote in Congress. They could have left it at one, but they said every state gets two senators. It doesn't matter if you are a big state like Virginia back then or a small state like Rhode Island, everybody gets two. Why did they do that? Why did they have this bicameral in the first place? The reasoning was simple. You wanted to get rid of the Articles of Confederation. It had established that every state had an equal say. Now you're trying to create a House of Representatives based on population that could dwarf the small states. The small states said, if you are going to impose that on us, we refuse to vote to end the Articles of Confederation. We'll live under that where every state has an equal vote. So again, here's the next compromise. We'll create a two-house system, and this was done by, his name escapes me. I mean, if anybody recalls his name, very, 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 very famous person who came up with the compromise that said, let's think out of the box. Why do we need a Congress that's one house like we had under the Articles of Confederation? How about two houses? One where it's based on population and one where it's based on every state is equal. And the key is that either House of Congress can block the other one. They would have to learn to work together, but that this way no small state could be bulldozed by the House of Representatives and no large state can be essentially stopped from doing anything as a result of each state having equal say so the small states can keep the big states. Okay, so we saw, well, I'll come back to Warren's in a minute. So we saw that the senators, they will serve a 6-year term. Each one of them gets one vote in the Senate. That means that that each state has an equal say in the United States Senate. I'm sorry, I'm getting distracted by all of these messages that are popping up. So I'm going to kind of avoid those messages and we'll talk about them at the end. Now, you saw that members of the House of Representatives serve 2 years, senators serve 6 years. I think we all know a president serves 4 years and is limited to only 2 terms. Why did they stagger these terms? 2 years, 4 years, 6 years. It was what we mentioned before. It's continuity of government. By staggering these terms, let's say that there's a populist uprising that they hate the party in power and that party loses the election. It means that there are at least some members of the existing institution, Congress or the president's, or, well, it's mostly Congress, that are there that can continue the functioning of government instead of replacing everybody with brand new people, which means, of course, it could take 6 months or a year before any of these people even know what to do and how to do it. So and they had that problem under the Articles of Confederation where everybody served the same 1-year term. So they said, we're going to stagger them so there's always somebody there who knows how things are run and can show the new people how to do it. So the staggering of the terms is very important. And incidentally, or parenthetically, I guess I'd say, the question has come up in discussion in some of my classes. How is it that a system of government like Germany prior to World War II, who had a system that was modeled on the United States, how was it that that they essentially elected um, a dictator and created the problems of Nazi Germany. Well, Germany at the end of World War I was told you have to become more democratic. And so Germans, as they're wont to do, say, well, let's take a look at what the best system is there for a democratic system form of government, which I guess is the United States. But we, being Germans, we can always improve on everything. And so we're going to improve on that. And 6 years for a member of the Senate? What if the month after we elect him, we determine the guy's an absolute jerk and needs to be taken out of office? Well, we're stuck with him for 6 years. And that's not a good democratic system. So we're going to have short terms. None of these 6-year terms, none of these 4-year terms. We'll have short terms. What happened in Germany was because of economic and social pressures with their short terms of office, including for judges, the Nazi Party was very popular in Germany, but only for a very short period of time, long enough to capture control of the elected offices in Germany. And then once they had those, they said, well, I guess we don't need elections anymore. So one of the things that protected the United States from something like a German Nazi party taking over was this staggering of terms, because nobody, Nazi party, Donald Trump, I guess with the exception of FDR, and even he wasn't all that popular all the time, nobody can stay popular for 6 years, and you'd have to stay popular for 6 years to be able to get control of Congress. And they also give, which we'll talk about in Article 3, lifetime terms to judges, which means that there are no elections at all. It's supposed to be free from the popular will. We'll talk about that in the near future. Moving on to our next slide. I'm going to give you this one real quick. It's a long explanation here. The Senate, and this only applies to the Senate, congressmen had 6-year terms. But the fear was, again, for continuity of government, if all of them are elected at the beginning for a 6-year term and they all become unpopular and get voted out after 6 years, all new people are going to come in and you don't have continuity in the Senate. So they said that for the very first Senate, this was only happened for the at the very beginning of the federal government. 1/3 of the new senators would get a 2-year term, 1/3 would get a 4-year term, 1/3 would get a 6-year term. And from then on, their terms were 6 years long. That allowed for this continuity of government problem. On to the next slide, please. And what do we got here? Okay. Who shall be a senator? They now have to be 30 years of age, up from 25 for a member of the House of Representatives. They have to be 9 years a citizen of the United States, and they have to live in the state that they represent. So slightly more stringent to be a senator than a congressman, but still, you did not have to be born in the United States. You don't need to be a natural born citizen. You do need to be a citizen, which could be a naturalized citizen, 30 years of age. Again, the argument is we need young, fresh blood to run this new country. Next line, section 4 of Article 1. The Vice President of the United States shall be President of the Senate, but shall have no vote unless the Senate is equally divided. So I think a lot of us are familiar with this. Congress, or the Senate rather, is presided over by Mike Pence, the Vice President. All he does, his job is to preside. He doesn't vote unless it's a tie. And since every state gets an equal number of two senators, ties are possible. They are going to be inevitable sometimes. President can cast the deciding, or the president of the Senate, who is vice president of the United States, can cast the deciding vote. But here, there's a flaw in the separation of powers issue. The vice president is now being mentioned here in Article 1, the legislative branch. Is he an Article 1 officer? Or is he in the executive branch an Article 2 officer? Vice president, and this was recognized very early on as a flaw, but nobody ever really considered it much until George Bush's vice president, Dick Cheney. Dick Cheney, as vice president, presided over the Senate. Can the executive branch can the president tell the vice president to do something? In this case, George Bush said that at the conclusion of his second term, all of the members of the executive branch of government are to turn their documents over to the National Archives. This is just a natural thing that's always done. They're to turn all of those documents over by authority and order of the President of the United States. Dick Cheney said, well, that doesn't apply to me because I'm an Article 1 officer and the President doesn't have authority to order me to do that. So here you have a man, Dick Cheney was claiming the only person that would have this power if he's right. He is a member of both Article 1 and Article 2 of the Constitution, legislative and executive branch. He backed down on this and complied with what George W. Bush ordered. Said, basically, I'm just kidding about that. But he did raise the issue, which academicians had looked at for years and said, well, what is the vice president? He's an Article 1 officer. And if he is an Article 1 officer, you'll see that an Article 1 officer cannot be impeached. But if he's an Article 2 officer, he can be. So it created an interesting debate there. Now, very often, the Vice President of the United States will say, unless it's likely that there's going to be a tie vote, why should I waste my time presiding over the Senate because I don't even get to vote. So they said that in the times where the Vice President isn't there to preside, the Senate shall pick what's called a President pro tempore, who will preside over the Senate. And by statute later on, this person, whoever it is the fourth in line in succession to the president if the three before him die or are incapacitated. Moving on to the next one. Senate shall have the sole power to try all impeachments. So we saw that the House does the impeaching and the Senate will try the impeachments. Interestingly enough, this is something that a lot of people don't know. It's only when the President of the United States is being tried for impeachment that the Chief Justice presides. But other people can be impeached as well. Any Article 2 or any Article 3 officer can be tried for impeachment. In those cases, the Chief Justice does not preside. It is the Vice President of the United States or the President pro tempore who presides over the impeachment process. So this raises something else. Obviously, we spend a lot of time thinking about presidential impeachments, but any member of the executive branch of government, Vice President, members of the cabinet, all of these people are subject to impeachment. And then the more common impeachment is on the judicial side. There are many, many more impeachments on the judicial side. A federal judge who has been determined to be incompetent, maybe due to age, or maybe they have taken a bribe. Those things are no-nos, and the House, if it becomes aware of that, can impeach a member like a cabinet member. Donald Rumsfeld almost got impeached. So that happens more frequently. And then on the justice side, Article 3, judges, most of the impeachments that have happened and most of the people actually removed happen on the justice side. So don't think impeachment is just presidents. And the other thing about what happens if you are removed through impeachment? Let's start with the president. If he is removed from impeachment, let's say in front of witnesses on Fifth Avenue, the president pulls out a gun and shoots somebody in front of thousands of witnesses. Odds are the House of Representatives would say that's not appropriate behavior for a president. We hereby impeach him. It would go to the Senate for a trial presided over by the Chief Justice of the Supreme Court. Probably they would come to the conclusion that shooting somebody on Fifth Avenue in front of all these witnesses for no apparent reason is probably something that should remove him from office. So this man is now removed from office. What does that do? Does he go to prison for murder? And the answer is no. Impeachment is limited. It shall extend no further than to be removed from office and disqualified to hold and enjoy any office of honor, trust, or profit under the United States. Could he then become a governor of a state? He could. Could he become a judge within a state? He could, but he could never hold a federal office again. So now let's say that after he's been impeached and removed from office, now he's going to be tried for murder. And he is found not guilty. Does he get to take his office back again? And the answer is no. Once he's removed, even if it turns out that he was wrongfully removed. When you're out, and you can't have it back again. Move on to the next slide. Okay, you've probably heard in recent years, just within the last 2 years, I think, where the Supreme Court said that holding elections, that is a local matter, issues of gerrymandering, that sort of thing, that is a local matter. It is a political matter. It is not something that that courts are supposed to look at. Courts stay away from, ostensibly, stay away from political issues and only look at legal issues. That is kind of nonsense under this article here. Times, places, and manners of holding elections for senators and representatives shall be prescribed in each state by the legislature, but Congress may at any time by law make or alter such regulations. So the states are responsible for setting up the running of elections, including for United States Senate and United States House of Representatives. The state legislatures determine the method that the election will be held in. But Congress does have the power at any time to step in and make or alter such regulations. What if state is holding a local election for governor? Can Congress step in and make any law about that? The answer is no. That is a completely local matter. It's only when it's for the office of United States Senator, United States House of Representatives, Congress does have the power to regulate how those elections are run. Congress shall assemble at least once in every year, And we don't need to spend a lot of time on that, although there are some interesting issues, but let's move on to the next slide. This one's kind of important.
Oh, excuse me, but we've actually exceeded our time.
You're kidding. Oh my God.
We set it for 1 hour. So at this point, let's open it up for those that want to have some discussion, and Bob can answer the questions. So tonight we're ending on this slide 16.
Slide 16, yes, I'll make a note of that. Okay, let me take a look at chat, or if, I guess we can open up the mics and people can ask. Well, no, then everybody's going to ask over each person. So let's take a look at what was written here first. Roger Sherman was the name I was trying to remember, the guy who came up with the bicameral Congress. Roger Sherman was an interesting guy. Most of the members of the delegation to write the Constitution were folks that were well educated. They were longtime politicians. Most of them were lawyers. Roger Sherman was a shoemaker, and he came up with the concept of the bicameral Congress, which probably saved the United States government, because without that, they never would have gotten rid of the Articles of Confederation. So could Congress pass a law to allow a vote by mail? The answer is yes, if it's a vote for a member of the United States Senate or a member of the United States House of Representatives. Now, in practicality, if Congress says, okay, there's going to be an election for United States Senator, for a member of the House of Representatives, for President of the United States, for the governor of your state, for your state legislature, for various judges in your state. If Congress asserts its power, they said, well, the part about running for House of Representatives or the House of the Senate, we can say, yes, you can do a mail-in ballot if they so choose. And then most of the states would say, well, as long as we're holding one part of the election by mail-in ballot, we might as well do it all. But the short answer is Congress can pass a law allowing vote by mail, but their authority would be limited to members of the House and members of the Senate. How many slides left on Article 1? Article 1 is the longest, and it's got some of the most important things. The emphasis, obviously, when they wrote this Constitution was that the real power of the United States was meant to reside in Congress. It was never meant to reside in the office of the presidency. And you will see that, and especially when we get to the war powers, which will be coming up next week, probably, when we get to it. Okay, other questions? I guess
I have a question.
Okay, who's speaking?
It's Carol Wallenow.
Okay, go
Okay,
ahead.
since a member of the House of Representatives does not have to be a natural-born citizen, if God forbid the president and the vice president both died, and that person, that speaker, was a naturalized citizen, not natural-born, what would be the next step?
Yeah, so let's put some faces on it. Let's say that Nancy Pelosi was not born in the United States. She was, but let's just say she was not born in the United States. And a disaster happens where both the president and vice president are incapacitated. She would not be eligible to take the office because she's not a natural born citizen. And so it would then go to the fourth slot, which would be the president pro tem of the Senate. And if he's not, then it moves on to the fifth slot, which I believe is the Department of the Treasury. So the head of the the cabinet member that's head of Treasury would become the next. And they've actually extended this. There's a law that was passed, I think, since 9/11, where they have carried this out. What if there is a disaster where so many people in line of succession die? So they passed the Presidential Succession Act, which I believe they carry out to 35 places. So if 34 other people in line die or incapacitated, the 35th guy. So you can look up the Presidential Succession Act. It tells you the order. Most of us are fairly knowledgeable about the first three, but yeah, they carry it out at least to 35 spaces. Okay, we have another question. None. Okay. Well, I'll tell you, we'll get into some real interesting stuff next week. I hope that we've kept your interest here. And by the time we get to Article 3, you are going to have a much better understanding of how this, the interaction of the three branches of government. So I don't want to give away some of the fun stuff that we're going to talk about, but I will just drop this one when we get to talking about the judicial branch of government. Should judges have a lifetime appointment? It's only in the federal system. No states do that. Does this make the judicial system immune from democracy? And of course, the question is, should it be immune from democracy? Should the judicial branch operate as a court or as a political body? Should people have the right to remove, they obviously have the right to remove any politician because they don't like what he's doing in office, they disagree with some decision he's made. Should we be able to remove a federal judge because we just don't like a decision that they handed down? And we can do it in the state system. Almost every state would allow it, but not allowed in the federal system, which creates the better system of judiciary and or the more democratic system of judiciary. So those are things coming up. Any other questions? You can always...
Yes, Bob. The idea behind the bicameral system, having the Senate and the House of Representatives, was that to any degree influenced by the British system where you have a House of Lords and the House of Commons?
They have a bicameral parliamentary system. Obviously, Roger Sherman was aware of that. You got to remember when they were writing this document, they wanted to distance themselves from the way things were being done in Great Britain. But that's why they went with a unicameral congressional system, or, instead of a parliament. But it became unworkable. And so Roger Sherman said, well, maybe, we've got that model of parliamentary government in England where they have two houses. Maybe we should consider that. After all, our foundations come from the British, so maybe we should. And ultimately, that's what they did. They created bicameral, so I'm sure it had an influence.
I have a question.
Yeah, who's speaking?
Yeah, this is Bruce.
Okay.
What's your opinion of 2 years for representatives? That seems a little short to me. They're barely in there and they have to turn around and campaign for their next term.
Yeah, that's very true. And the thinking was kind of like what we talked about with the Nazi Germany situation. Well, what if after even just a couple of months of having elected this guy, we decide he shouldn't hold this office? We're not stuck with him forever. We're stuck with him for a relatively short period of time, which is 2 years. And remember, he cannot be impeached. Only Article 2 and Article 3 officers can be impeached. But we'll talk next week in one of the subsequent slides about the system of Congress exercising authority over misbehavior by the members of either the House or the Senate. They have their own rules on that, but it's not through the impeachment process. So the 2-year thing was, if we've made a mistake and we got bad guys in there, we can get rid of them quicker. But
You could say the same thing for senators who are in there for 4 years.
senators in for 6 years.
Or 60. There you go. That's even longer.
Yeah, but the thing
I
was
think three for representatives and 5 for senator.
well, again, that's the determination was made on the 2, 4, and 6. There was a compromise. The key that I guess we need to understand is the purpose of the staggering of the terms instead of everybody serving the same length of time, because you can understand if the people in charge become unpopular and they're all thrown out, the folks that come in, it's going to take them, the learning curve. It could take them 6 months or a year before they even know what to do. And can our nation survive that? I guess Trump has shown us that maybe we can't survive it, but that's why they staggered them. Why 2, 4, and 6, and like you said, not 1, 3, and 5? It's just what they agreed on.
Was there ever discussion about limiting the term to the number of terms you could serve?
Well, it was part of the Articles of Confederation where there was a limitation, and that didn't work very well. So that was the reason. And one other thing, obvious, I say obvious, some people might forget their history. Presidents were initially not term limited either. All of the thinking was in a democracy, hey, if they're popular and doing a good job, they should be able to be reelected over and over and over again. It's just we should have these periodic elections to determine if they really still are doing a good job. But if they are, we can keep them. And, Franklin Roosevelt rode that to 4 elected to 4 terms as president. And after that, constitutional amendment was made to limit a president's term to only 2 terms. Discussion at that point was made, should we put limitations on members of Congress? And the determination was made not to. Now, interestingly enough, in order to amend the Constitution, there are 2 ways to do it, but only one that is practical, and that is that the amendment has to be brought up in Congress and approved by Congress and then sent to the states for ratification. And you can imagine that they might have some self-interest in not including themselves in term limits like they did to the president.
Can the president or Congress postpone an election? Major
national
pandemic
election,
going on, major problem. Can you postpone it?
no, we'll probably be into this section next week. I could look it up for you real quick, but there is a clause in the Constitution that says there will be an election in November. There will be a federal election every November, and or every other November, and the only way that could be changed is, I'm not even sure an act of Congress would do it. It might require an amendment to the Constitution, because the Constitution is very clear. You cannot suspend, because what did the king do when he didn't like the way Parliament was doing stuff? He would suspend them. So we operate under an electoral system, and if a president doesn't want something to happen, he can just suspend elections. This happens in what we call third world countries. It can't happen in the United States. Can't suspend a national election. You can, the individual states can suspend statewide elections, local elections, but federal elections have to go on.
Just suppress the vote.
Yeah, well, that's And I guess we'll talk a little bit about that in probably 2 sessions from now.
Okay, I'm going to cut this off because we are losing people, but I just want to remind you that if anyone missed this that you know of and they want us to hear the discussion and see the whole thing, we will be posting the video again. So tomorrow I'll send out a notice to everyone that attended and to those that didn't, where the video can be seen. So thank you all.
Well, I just want to toss in one thing, preview of coming events. We will be getting to the express powers of Congress pretty shortly. Probably start it with our next session, towards the end of the next session. We'll be talking about the express powers of Congress. These are things that Congress can do and the president has no authority over. And the really interesting dichotomy to look at, we're going to look at the war powers that are granted by the Constitution to Congress. And then when we get to talking about the president, we'll talk about what his powers as commander-in-chief are. And you will see that there are severe limitations under the Constitution on the war powers that a president has. And we know that that has been blurred. We'll talk about how that got blurred. But
okay, I'm going to call an end to this now because if you guys know my husband, he could keep talking about this all night. And then we wouldn't have anything to look forward to in the next sessions. So good night, everyone, and we look forward to you seeing you next week. All right.
Thank you.
Bye-bye.
Bye. Thanks.